enormous hole that prevents the that goes to race, national origin, gender, color, but doesn't protect against religious speech or religious discriminatory speech. But the Department of Education has promulgated regulations and has offered guidance that when the discrimination based on religion is such that it goes to actual perceived shared ancestry or ethnicity, that it's prohibited discrimination under the federal statutes. The Department of Justice does have under both Title VI and Title IX and Title IV jurisdiction the ability. Title IV desegregated the schools, prevents discrimination based on religion. Title VI prevents discrimination based on national origin in any federally funded program, which is every school in this country. And Title IX requires a free and equal education for everyone. The Department of Justice can get directly at religious-based discrimination. The problem is that it's a very tricky kind of area under the law because you have to balance, and you have to first get to this more complicated question we were discussing, which is, what is the impact on the child? What constitutes discrimination? When does it cross the line between a discourse on a public policy question to become discrimination that prevents child on equal terms being able to get an education? And how do you balance the First Amendment and other rights of the students who are engaged in expressive conduct? And so the courts have been very delicate around this issue. Particularly, they've been reluctant to deal with cyberbullying, which has become an increasing problem. The courts have provided very little guidance there, and what guidance they've provided is they give wide latitude to speakers on social media, less so in the school building, in the school house, but they have left some room for there to be negative, hurtful kinds of comments that don't go as far as those kinds of comments that would prevent children to get an education on equal terms.
So what are we seeing? I should mention, those of you who may not know, my former colleague here, who I just think he's done some great social justice work, was with the Department of Justice, and under his direction, DOJ authored the Ferguson Report, and I actually snubbed my nose at it because it was coming from the Department of Justice until I read it, and it was one of the most balanced, insightful. You could hear Jonathan's advocacy coming out in that report. So if you haven't read it, you should do it. But I made me think about that because I'm just wondering, what are we seeing that's actually working? So these are the standards. It seems like we're like climbing this mountain. Do we know of what strategies have been most effective when we're looking at protecting children in schools?
I mean, I think these folks may know better than I do. Okay. I do know that the courts there's been a number of consent decrees.
It's deliberate indifference.
It's deliberate indifference. And what the court remedies, if you look at the injunctions that have been entered, are not very effective. They have a policy, collect some data, whatever. And it doesn't provide the kind of leadership inside the schools to make the behavior unacceptable, which is what.
So if I'm correct, when we're looking at deliberate indifference, there has to first be this great policy. Is that correct? That there has to be a policy in place, and that the school district is demonstrating deliberate indifference to the policy. Brenda, were you going to?
Yeah, I was just going to add something. So one thing that we did at Muslim Advocates, in part because we had so many parents out of this fear for what can I do, we drafted a letter to every single state superintendent, or whatever their title would be, varying states, that's responsible for education in their state. And in that letter, we highlighted, similar to what you just went through, the legal obligations as a public school district in that state, and what under Title VI and prohibiting discrimination, as well as potential liability there in Section 1983 as well. And what we've done is we attached to that, which a fantastic letter that went out the last day before former Secretary Arne Duncan left and before incoming Secretary King started. On December 31st, the letter went out, a Dear Colleague letter that highlights not just the obligations of each school district for what they should do, but also highlighted some potential strategies for how to talk about these issues in school, and highlighting the climate for that. And after we sent that letter out, we got so many wonderful emails back from state superintendents saying, thank you. We're not aware if this is happening at the schools, but we're going to look into it. We're going to have these conversations with our school districts. And we've also asked parents